Can I have ask you all to stand, please, for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, can I have the clerk call the roll, please?
I'm here.
Here.
Commissioner Onslaught.
Here.
Commissioner Rodriguez.
Here.
Commissioner Kessley.
Here.
All right.
Okay, item number 4 on the agenda, public comments. This is a time for any of the public to speak on any topic that's not on the agenda. I have no cards, and I don't see any members of the public, so we'll move on to number 5. Excuse me. Approval of the May 24th, 2018 minutes.
Move approval.
Do I have a second?
Second. Yes.
Okay. Oops. Okay. Motion passed. Item number 6, PL 17-0119, Rancho Sespe Workers Improvement Association Corporation. Staff.
Good morning, Commissioners. My name is John Okendo, Senior Planner with the Ventura County Planning Division, and I'll be presenting the project under consideration today. The item on your agenda is Rancho Sespe Farm Worker Housing Complex, case number PL 17-0119. This is a brief rundown of project information. So the application is a request by the Rancho Sespe Worker Improvement Association for the approval of a planned development permit, allowing the continued use of a 100-unit farm worker housing complex. The site was previously permitted under CUP 4145. This use permit associated with the original development was determined by the Planning Division to have expired in 1995. The project is located at 2950 East Telegraph Road in the unincorporated community of Piru. There is no new construction proposed with this project. The applicant is the Duncan Group and Anna Corbett on behalf of the Rancho Sespe Workers Improvement Association Corporation. And today we have representing the applicant, Sespe Consulting and Caitlin Brooks. So moving on to project location information. So to orient yourself, the project is located south of State Route 126, also identified as Telegraph Road, in the eastern portion of the county within the unincorporated area of Piru. The site is approximately 3.5 miles east of the city of Fillmore. For those of you that travel along Highway 126, you're probably very familiar with the site. So onto the site address. The site here is highlighted in red. You'll see the project is surrounded by agricultural land uses with various types of farming occurring on the surrounding properties. For zoning information, so it's relatively uniform as far as the zoning area plan and general plan designations. It's all oriented towards agricultural. The site itself is zoned agricultural exclusive with the 40-acre minimum lot size modifier. As far as the code, under the current county zoning, the use of a farm worker housing complex is permissible with a planned development permit. And that planned development permit is subject to Planning Commission approval. So to give you an idea of the present condition of the site, so here we have the entrance into the project. The site was inspected by staff when the application was filed. So here we have the entrance into the site. It's a stop. You can see the stop controls as well as the front landscaping. 126 is on the right-hand side of the photograph, and you see a partial view of the front buildings there. So we have the buildings closest to the street side here, the landscaping in front of it, and the bus turnaround. This is a school bus turnaround, so it's provided originally to provide a safe means of entry into the site for school buses. This is the other adjacent side of the front entrance. Again, to give you an idea of what the conditions of the buildings are. Here we have a view south of the project site. So we are looking on the western property line, south to the project site. So we see the landscape buffer for the adjacent agricultural uses and the residential buildings on the left-hand side of the photograph. And this is to the other side of the development. So this is the eastern property boundary looking north. You can see some of the covered parking areas for the site, as well as the landscape setback on the eastern property boundary. Here we have a view of the community buildings for the subject property. So the site was included multiple buildings in order to develop the site. Part of it was community facilities that would be provided on site, community buildings for use by the residents. And additionally, the amenities that would be provided for the site. So here we have the soccer field, which is located on the south property line, which is for use by the residents only. So on to the project background. Here's an abbreviated timeline of the events related to the decision that a new discretionary permit would be required to bring the property into compliance with the Ventura County Non-Coastal Zoning Ordinance. Regarding the original approval and permit, on June 25th, 1985, the Board of Supervisors certified an environmental impact report and approved conditional use permit 4145 for the construction and use of the 100-unit farm worker housing complex. The development was constructed in multiple phases between 1987 and 1992. So at the time of the Board of Supervisors action, the CUP was granted for a 10-year period and the term was to expire in 1995. Under the code applicable at the time of the Board of Supervisors action, a CUP was required for the development of farm worker housing complexes. Additionally, a provision to extend the approval was included in the original approval. However, it was determined that that was not exercised. In 2003, Ordinance 4281 was adopted that amended the NCZO definitions and standards related to farm worker housing and animal caretaker units. The key change for this project was the requirement to obtain a CUP for farm worker housing was replaced with the requirement to obtain a Planning Commission approved PD permit. This was a permissive change in the applicable code provisions. However, due to the expiration and application of our non-conforming, our present non-conforming ordinance, staff determined that a new PD permit would be required for the continued use of the site. So in order to bring it into conformance, and also to, there would not be a expiration date consistent with our present interpretation and enforcement of the code provisions. So the project under consideration today, the applicant is requesting again a plan development permit for the continued use of the existing farm worker housing complex. No new construction is proposed as a part of this project. Again, that will be emphasized. The complex has 100 units, 24 two-bedroom units, 49 three-bedroom units, and 27 four-bedroom units. The on-site amenities included in the original development of the facility was a laundry facility, on-site management office, a child care facility, a community center, several playgrounds, a soccer field, and an outdoor basketball court. The complex provides 200 covered parking spaces for residents and 37 visitor spaces, which will have to be maintained with the continued use of the site, as well as the aforementioned school bus stop and the turnaround. The site was developed with the on-site buffer, so a 100-foot perimeter buffer, building setback requirement with landscape planning from the adjacent agricultural land uses was provided. Water is provided on-site by a well regulated by the California Water Board, and wastewater is handled by County of Ventura Water Works District 16. With an approved PD permit, the project would no longer be subject to an expiration date. So that would bring them again into compliance. So here we have the site plan for the site. If you see, on the left-hand side of the screen is State Route 126. The key sort of takeaway is the site was developed with the perimeter driveway access around the site, and we have the landscape buffers on the eastern, western edges, as well as the site buffer with the soccer field on the south edge. Landscape plantings occur along all of these edges. The site buildings themselves, the site was developed in 2 phases, so between 1987 and 1992. Originally, only the front residential buildings were developed, and then at some point, in 1992, the community buildings and then the southern half of the development was built. The blue line there is the 100-year floodplain, so it only occurs on a small portion of the edge of the site. The rest of the site is not within the 100-year floodplain. So regarding the California Environmental Quality Act, the proposed project was determined to be subject to CEQA. With their approval action in 1985, the Board of Supervisors certified an environmental impact report that evaluated the environmental impacts of the construction and use of the facility. Potentially significant impacts were identified to several environmental categories, including the direct loss of agricultural land. At the time of the approval, the final EIR also identified potentially significant impacts to land use, pesticides, housing and population, traffic and circulation, drainage, soils, water, air quality, biota, public services, and public costs and revenues. As the proposed project consists of only the continued use of the existing farm worker housing complexes and does not include any physical changes to the site or the environment, we've determined that or we're recommending with this action the adoption of an addendum for the project. That includes a statement of environmental findings, as well as a discussion of why the project does not meet any of the CEQA criteria for, requiring the preparation of an EIR. Regarding the proposal, so we did do some changes to the recommended conditions of approval. That is the errata memo that's been provided this morning. We are recommending changes to conditions 21 and 22 to help better define the compliance procedures and the specific conditions related to the operation of a farm worker housing complex. So the original condition provided in CUP 4145, the language is included here. Under the original approval, the property owner was required to notify all tenants of agricultural spraying operations on adjacent properties. So that's part of the difficulty. In order to achieve compliance with this condition, the property owner is going to have to reach out to those property owners and let them know that they're, there, and they should obviously know that they're operating a farm worker housing complex already, just based on the existence of the facility. But the intent of this condition is to get some level of cooperation between the two property owners.
It's the applicant's obligation to contact the adjacent property owners and solicit a schedule of spraying, et cetera?
Potentially, yes.
Okay, thank you.
So that was the original condition. It was very short, and then basically just required them, as the facility was continued to be operated, that they had to notify residents of agricultural chemical applications. We updated the condition just based on our standard practices to be in our current format. So we have kind of a structure how we do conditions of approval in the current format. And that includes a purpose statement, the requirement statement, documentation statement, a timing statement, and then monitoring and reporting. So we've basically taken that condition and put it into that format. So the applicant has a responsibility of reporting to us compliance with this condition. In this case, the timing of that is going to be before we sign off on the zoning clearance for use inauguration. So once that is determined, or once they come to us, so they're going to have 12 months to report back to us and state that they're in compliance with their conditions of approval. Part of that would be filing the tenant notification plan. So we've asked, the applicant approached us and asked us to give some additional clarification on what the responsibilities would be. So the language that we've added is in red, and the amendment is to the requirement condition number 21. So what we've stated is to provide an additional clarification, which is, so they have to file the tenant notification plan with us, and as far as the operations, when they are notified of the operations by the adjacent property owners. Additionally, there was a condition requiring compliance with the occupancy limitations. So the site itself, all of the 100 dwelling units have to be occupied by qualified farm workers. They will be reporting to us on an annual basis. In this case, this was the original condition. Same issue as condition 21, which is this was the old format. So it was just a kind of a basic statement, not really giving us information on reporting requirements or timing or when this has to be implemented. Now we've updated it to be in the current format, and the applicant has, so the requirement, they're going to have to report back to us that all of the occupants are principally employed in agricultural production in the county. And also, too, it was updated to our current provisions, which do permit occupancy by the farm worker's household, as well as their, if they become disabled, they are permitted to continue to occupy the unit.
Excuse me, sir.
Go ahead.
And the applicant is to verify that how?
So they're going to be reporting to us in our annual verification.
No, that's not what I mean. I mean, is the applicant going to require some information from the employer? They're going to verify employment? How do they verify farm worker?
Sure. So the applicant can give us a little bit of a better idea of this, but they do report to HCD because they do have additional state requirements based on a grant received for the development of the facility. But they would have to give us information basically. Right now, the format or the acceptable format is a signed affidavit from each occupant that the occupant meets the requirements. So they have to go to each occupant of the dwelling. We have an application form that basically provides that. For 3 units or more, we can receive additional documentation, basically who is occupying the unit and proof that they're, they are meeting the verified worker requirements.
Okay. And I raise this now, and hopefully the applicant will address it later. But in condition 22, there's a reference to household with no specific restriction. And I understand that a farm worker has to be head of household there, but there seems to be no limitation on the number of other people that can occupy. And when it says household in condition 22,
Sure.
I want to know what that means.
Sure.
And I raise that now to maybe to be discussed later. Now, obviously, I mean, it's a great project, and I appreciate that, but we want it for farm workers, and we
Absolutely.
Yeah.
On that, and we may defer that question to County Council. We did have a brief discussion based on that issue and how it's defined. They can help shed some light on that also. Remember, the language in the condition is based on the current language in the code. So the requirement and limitations have been defined by the non-coastal zoning ordinance.
But the condition 22 specifically referencing household with no
Correct.
limitation. Okay, thank you.
So in terms of the requirements, we've stated we're adding the language in red to allow for the reporting back to us. That would include this information, the annual schedule of rental income for each occupant of the dwelling to verify that they're meeting the farm worker employment criteria. So that brings us to staff's recommendation. we've reviewed the application, the analysis presented in the staff report. As far as compliance with the zoning ordinance, what we have here is the use of existing buildings that were determined to comply with the applicable provisions of the codes, the policies, and of the area plan, the general plan. So in and of itself, the site, if it were being built or proposed to be built in this manner, it would be, the same recommendation. However, in this case, we have the use or the continued use of these existing buildings. Accordingly, that would lead us to our recommendation, which would be an approval recommendation. We also want to make sure that we modify the recommendation to include those changes to condition 21 and 22 based on the errata memo submitted to Planning Commission. So with that, I would say that concludes staff's recommendation. Thank you for hearing this project. Myself and the applicant's representatives are available if the commission has any questions.
Okay, thank you very much. Commissioners, disclosures? Commissioner White?
Are we going to have a presentation by the applicant?
Yes, we will. Yeah.
And a question, are the recommendations? Huh?
Disclosures first. Disclosures.
Oh, I'm sorry. No, I have no disclosures.
I have no disclosures.
Well, I'm told I don't need to disclose it, but the applicant may wish to know. I did represent Rancho Sespe 100 years ago, it seems, and was general counsel involved in unlawful detainers and the Agricultural Labor Relations Board litigation. So that's been some 20, 25 years. I've had no contact with any of the principals involved in that in 20 or 25 years. So I think I should disclose it, even though I'm told I'm not going to, or don't need to. Anyway, that's my only disclosure.
Commissioner Kistler?
No disclosures.
And I have no disclosures. I'm familiar with the property, but no disclosures. Okay, questions of staff? Commissioner White?
Sorry for jumping the gun there. Are we going to have a presentation by the applicant? That's first question.
I have two speaker cards.
Yes.
And the other question is, the recommendations talk about EIRs. Is there not more recommendation to approve the new permit?
So we are recommending the adoption of an addendum to an EIR. The EIR was previously certified through that action for CUP 4145. Effectively, it's the same project.
Understood.
Our action today is to find that an EIR can be adopted for the subject property. And that action.
Okay,
yes.
That's what I'm looking for.
No other questions?
I have a question.
Commissioner Elstrom?
Could you give us the total population of the residential units out there? The total population?
250 residents.
250,
Yeah.
which doesn't seem a lot. I think initially, weren't there 300 or 400 people involved? Well, I guess they should wait till I should talk to them.
In terms of the occupancy rate, I think the applicant would be the best to discuss that.
For my own edification, why the change from CUP to PD? What brought that about? And what are the distinctions between the two other than the
Sure.
expiration period?
The expiration date is key in this case. So at CUP, we still, as a practice, the planning division does place an expiration date on it. The short version of it is, as far as the differences in the change, that would have been based on the presentation or the analysis presented to the Board of Supervisors in 2003 when the changes were amended. However, what we would state at the counter, or in this case too, which is it was a permissive change. So it was basically acknowledging that the development of farm worker housing complexes in agricultural
Right.
is one of those by right uses. That doesn't mean that every property can develop it, but basically, it's I think that change is key, which is it is more of a permissive land use approval.
Well, thank you. There was a hiatus from 95 to 2014, and then a compliance agreement in 2016. Do you have an explanation for that?
The dates on that, as far as what the transactions were, the only thing I have to go by is what the written memos are. So I don't know what type of information was communicated. I think it was just one of those things that fell through the cracks at some point. But we did at some point go on record that the expiration, in 2011, that the expiration had occurred. And that in order to bring the property into compliance, the property owner would be responsible for submitting for a new land use approval. That gets confusing to people who inquire about the project. You know, it's an existing building, how can this, you know, be so? The key takeaway for us is that, you know, in terms of the non-conforming provisions, when we have an application that has this happen, we do have to go back and address it with a plan development permit. So
Right.
even though it's a permissive
Yeah,
change.
I have no problem with its use within the zone. I was just curious as to the distinction between the CUP and the PD.
Yeah.
I'm going back to, and I would address the applicant later also, about the issue of who can reside. And I'm somewhat troubled by the fact that people can be grandfathered in, and with no expiration date, this place could become a senior citizen project, and we may not have it available for farm working housing. That's the way down the line, I understand that, but what was the reason for including retired people, not actively farm workers?
That change was included by me, and it's based on the language provided in the present language of the non-coastal zoning ordinance. So that is effectively in our ordinance to allow for occupancy based on those criteria.
Okay. And the language specifically that concerns me is the reference to members of farm worker household, if any, may also occupy said dwelling unit. And I don't know, the choice of the word household is bothering to me. I understand there's probably a problem with nuclear family, et cetera, and I suppose it's hard to define, but isn't it rather loosely worded? That uncles, nieces, nephews,
Sure.
not farm workers?
I think county council can probably better weigh in on this. As far as the wording and the inclusion of the language, again, that was based on the current language and allowances in the non-coastal zoning ordinance. So it does specify household.
Are you awake over there?
I am, and I don't have much to add besides the concern that you acknowledged about defining family, and you know, we can't say biological relatives, and it's, you know, First Amendment law really constrains what we can do in terms of defining what a family unit is.
Right.
And so I think maybe the applicant's, you know, a better one to ask about that issue.
Well, I'll talk to the applicant
Okay.
about it too.
So the applicant, when he or she comes up, can speak to the intent of the wordage in the ordinance as you've written it?
I think probably as far as what to expect in terms of who is going to be in that household. However, for us, we would state that in order to meet the criteria, basically the head of household would have to meet the verified worker requirements. As far as what the relationship to those the other household individuals, the applicant can probably give you an idea of what their requirements are as far as the leasing and other practices.
Understand.
Part of my question dealt with the fact that in some other situations that I've known over the years,
Sure.
Agricultural farm workers have subleased portions of their premises, and and I guess it depends on how rigorously the applicants adhere to their
Sure.
CUP, but I didn't want to fall in that situation. And the term household is too loose for me. I don't know how we can do better, but
Sure.
yeah, that's all. Thank you.
Just a point of clarification or for my information. The holder of a CUP holds it for whatever term is indicated on the permit, subject to renewals, correct?
Yeah.
And maintaining the validity of the CUP requires them to file for an extension or renewals.
Correct.
Correct?
Yeah.
It's not Planning Commission's responsibility to say your CUP's,
Correct.
expired.
Correct.
And so, all these CUPs, this one today, obviously, it's a past issue, but any CUP, the responsibility is to renew it is on the person who holds the CUP. or the-
Correct. And what we found was there was no evidence that the application itself had been extended through that period. Had they gotten through the 2005 extension, this would be a non-issue. They would have been in compliance at that time. It's a tricky provision of the code, and I hesitate to get into it too much when we're talking about hypotheticals, but in this case, what we have is, an expired CUP, and the intent of the applicant is to come into compliance with the expired use permit provisions of their compliance agreement, and in order to do that, they have to have an approved PD permit.
Okay, thank you. Speaker cards, excuse me. Presentation by the applicant. I have two speaker cards. Caitlin Brooks.
Okay.
Good morning, Chair Rodriguez and Planning Commissioners. My name is Caitlin Brooks. I'm a planner with CESP Consulting at 374 Poli Street in Ventura. I'm also the project applicant's representative for Rancho CESP Workers Improvement Association Corporation and the property managers, the Duncan Group. We would like to thank staff for their presentation this morning. As staff presented, Rancho CESP has been in operation since the late 80s. And pending the approval of the permit and conditions, will be allowed to continue to operate without an expiration date. We appreciate your consideration for this project, which is a fundamental component to supporting agricultural operations that are vital to our county. We request that you move forward with staff's recommendation to grant this permit so that Rancho CESP can continue to provide housing to our county's farm workers. Jorge Almeida from the Duncan Group and I are both here to answer any questions you might have. Sorry, I'm recovering from being sick. We provided comments to staff on the conditions that we received last Thursday, and we are pleased to let you know that we are in agreement with the revisions as shown to you today, both for the notifying of agricultural spraying and for annual verification of farm workers. And to address some of your comments, as Jorge let me know, it's very rare to have retired farm workers as part of the Rancho CESP population. He said he thinks it's less than 1% of the tenants at Rancho CESP. The definition of, I'm not sure if there's a specific definition of household in the non-coastal zoning ordinance, but that's really where that language came from. And as part of their annual verification process, Rancho CESP, the Duncan Group fills out a form that specifically states how many members are in a household in each unit. And so I assume it's family members, but Jorge can speak to exactly how they verify that. But for employer verification, they fill out an application that shows who their employer is so that they can verify that they are farm workers before they can move in.
Excuse me, once again, do they get an employer verification back? Does the applicant get that back for the individual?
Here, Jorge, you can speak to that specifically. I know that it's my understanding that they fill out an application when they are moving in that has the employer information.
I guess, Jorge, my concern isn't, stay up there.
Yeah.
Is and has always been verification, that this is for farm workers. We need that, but we want to make sure that it's reserved for farm workers and immediate families, but the definition here of household seems to possibly could extend that. And I've been involved in situations where people sublease. Anyway, that's my concern. I want to know how you verify.
Oh, okay. We have a second speaker card, Jorge Alameda.
Oh, I'm sorry.
Go ahead.
Good morning. My name is Jorge Almeida. Thank you for having me in front of the commission. I appreciate the opportunity. I represent the Duncan Group, and Rancho CESP is one of the 13 properties that I manage under my portfolio from Santa Barbara to Fillmore. I completely understand the concerns, and I am going to try to address it as well as I know. I have worked with farm worker families. I have 18 years of experience working in housing authorities, managing permanent farm labor complexes, and also seasonal farm worker complex residents. So I am very well versed in what the USDA requirements, which is the funding source for these particular complexes, operate. People's Self-Help Housing is a very structured and a very professional company that we definitely follow the rules. And I take special consideration of Rancho Sespe because it's kind of a unique type of project. Under the People's Self-Help Housing, we have only 2 complexes that are under this category, which is in my portfolio, which is Chapel Court in Carpinteria and the Rancho Sespe in Piru. When we're talking about family members and residents that are farm workers, our eligibility requirements are the head of the household needs to be a legal admitted person in the country to work, and then he works in farm labor. Actually, the way that we verify this situation is we take all the income sources that the tenant provides, and then we do third-party verifications, meaning that we send verifications to the employers to make sure that actually they work in farm labor. There could be actually individuals that work in agriculture, but really is not related to working directly with the product, so they might not qualify, and we put special attention to that as well. Now, under rural development regulations, the head of the household is the only one that needs to meet the requirement of $5,752.52 annually coming from farm labor activity to qualify as a farm worker and being able to have access to the housing. The remaining family members not necessarily need to be working in farm labor according to rural development regulations. Nevertheless, there are income limits, and taking those incomes as a whole, they still need to qualify, and that's how the rent is prorated, and they receive rental assistance from USDA. We pay special attention to the fact that the residents follow the rules. When we were talking about grandfathering the unit because they're disabled or retired, it's extremely rare in my experience that these families are actually going through this process. I have only one family in Chapel Court in Carpinteria who had grandfather that condition, but is extremely rare. In reality, once the original farm labor person passes away or moves to something else, then the remaining children, they move to other activities and really they don't stay in the complexes. And then when we're talking about family size as well, we have unit standards. So depending on how many bedrooms we have, we allocate how many people could live in those units. And right now we are, in a way, cleaning up the house because there are units that are underoccupied and there are units that are overoccupied. So we need to transfer those that are living 2 individuals in a 4-bedroom unit, which is not effective. So we are doing whatever is possible to come into what is supposed to be the correct thing to do. I hope that this more or less answers your question.
It does. Thank you, sir.
You're welcome.
Any other questions of the speakers?
No?
Yes, I have a question of either of you. You manage in your portfolio 12, 15, 17 separate properties.
Yes, I manage 13 properties.
Is there an off-site property manager that you work through?
Definitely, yes. Each property has a property on-site manager, plus maintenance staff, depending on the property and the size of the property. The manager on Rancho Sespe, her name is Leticia. She's been in the complex for about 1.5 years. She came without experience, but she's been catching up fast. It is a kind of a unique complex because we deal with a board member council for the residents. So sometimes they could argue what should be the rules or not, but it's very straightforward because rural development has the regulations well established, and that's what we do.
Is she responsible for ensuring that the rules are complied with on the property?
Yeah, they need to get the training. They go to a USDA training to understand exactly what needs to be followed and how to follow the rules and enforce those rules as well.
The local community council, for lack of a better description, how often do they meet?
Every Tuesday of every month.
Okay, and they go over issues related to the community?
We do. As a matter of fact, we just had our last meeting last week, and then we talk about the commission meeting today. We also talk about resident issues, suggestions to improve the conditions of living of the families, as well as addressing issues on our part, how to ensure that the residents follow the regulations and rules of the complex as well.
Okay. I have similar, I guess, reservations as Commissioner Onstadt did on the issues of occupancy and qualified occupancy. And so every residence there is the qualified number one person whose name is on the lease or rental agreement. That person is qualified by your corporation to be there. Is that what I'm hearing?
So every family, in order to continue to qualify for housing, they need to recertify every year.
Okay.
As you could understand, the company, our management company, the Duncan Group, has been in charge of this property for about a year and a half, close, something like that. And we have made a major turnaround, and we are hardly working. I mean, we're working very hard to get everything into compliance. We have identified these situations, and we are actually taking care of that. We have 3 families that are now on eviction process because they were not meant to be in that complex, and this was never done before. There's actually people that have been living in the unit and they are not listed on the lease. That's something that I do not appreciate, and it shouldn't happen. So I've been with the company only for about 8 months, but I like to get results done. I believe that the people that deserve to be in those complexes need to be there, but those that are not, they need to be, unfortunately, leaving because there's a need, and those families that are actually in need and working in agriculture are the ones that deserve to be in those units.
So it's the on-site property manager that's responsible to ensure that the residents, because she is there every day and knows what's going on, she's responsible for notifying you or that there's a residency problem or a violation of residency issue, and then your corporation moves forward to address it as you're doing now.
Yes, sir. Yes, definitely. That's actually one of my main priorities is to get the feedback from my property managers and sit down with them, whether it's maintenance, whether it's the board member council, and the managers on site, and then we address the issues. I have a long list of things that needs to be done, but we are slowly but steadily getting what needs to be done.
Okay, I had a question about occupancy, maximum occupancy. I don't know if you can answer that or staff should answer that. Because we have obviously different size of units.
Definitely.
And
by USDA regulations, actually there is called the occupancy standards, and there's a limit for how many people could live in a unit. So for instance, the rule is actually, let's say you have a 2-bedroom unit, the max will be 5 because they use the bedroom, the living room quarters also as a bedroom. It could be used as well. And then on a 4-bedroom unit, 8 people.
utilities. Is each individual resident billed directly by the utility?
Yes, and they're individually metered.
Okay,
Yes.
all right. I notice you have covered carports.
Yes.
Is there any effort to explore solar paneling to cut cost?
That will be fantastic, of course. On our last meeting, we were exploring the issues about what money we have available. We've been discussing the reserves available with USDA. Nevertheless, because of the age of the complex, it does require a lot of maintenance. And asphalt is one other item that is a priority. And we're exploring possibilities and trying to find funding to correct these situations. We are constantly looking out to improve the conditions.
Okay, thank you very much.
Thank you,
I
appreciate
have
it.
one moment. Excuse me, sir.
Commissioner Armstrong.
Did you say that you are in the process of removing or evicting 3 families that don't qualify, or 3 persons?
Yes.
Is that, so you have in fact, okay. There is a process and you are pursuing it. Is it a standard, it must be a standard eviction, I guess.
Okay, so there's also different regulations and then landlord rights and obligations. So in this case, USDA also allow us to evict someone that doesn't qualify. So the process is we serve them with a 30-day notice of termination. If they don't comply with it, then it goes directly to our attorney, and the attorney serves the notice, and then we go to court, which I have gone several times since I came. So I am not the most likable person anymore.
Thank you, sir.
Thank you. Appreciate it.
I like y'all, right?
Okay, any other questions of staff? Just for the record, I guess, I don't see anybody in the audience, but we'll open the public hearing. I have no cards. Nobody's stepping forward, so we'll close the public hearing. Okay, comments by commissioners?
Well, I've observed outwardly at least, the operation since its inception, and at least for all outward appearances, it looks to be a well-managed, well-taken-care-of project. It certainly services a need. I was concerned that it be maintained for farm worker housing, but it seems like there are rules and regulations in place that will ensure that, so I'm very much in favor.
I would echo Commissioner Onstott's comments. It's incumbent upon the property manager, the on-site property manager, and the property manager of the complex, your corporation, to stay on top of that. This is a unique situation, as you know, and there's obviously a need for farm worker housing, being what it is here in the county. So I applaud what you guys are doing and trying to do. And now you don't have to worry about an expiration date on your CUP. Okay, Commissioner White.
Well, I think all of us want to support agriculture in Ventura County, and a big part of that is having farm workers, and farm workers need a place to live, so this is exactly the kind of project we need to support, and I intend to vote to support it.
Commissioner Kessler.
Yes, I am. I'm also very supportive of the farm worker housing complex. I think it's very, very, very needed, and I'm also grateful to hear that you're working on things like asphalt and landscaping, because from my perspective as a property manager, it's sort of one of the things I did see that need it, so I'm glad to hear it. Also, I applaud you for taking steps and measures to ensure that it stays farm worker housing, so I'm supportive of it.
Okay, can I have a motion?
I move staff recommendation.
I'll second.
Okay, motion passes. Thank you for coming. Moving on to item 7, discussion, report by Planning Director on board actions and other matters. Staff.
Good morning, Chair Rodriguez, members of the Planning Commission. My name is Winston Wright. I'm sitting in for Kim Crowhart, who is not available today. Just one item here. Just a heads up that Chris Stevens will be at the next commission hearing on Kim's behalf, and will give, and Chris is the Resource Management Agency Director. He will be provide a short status update on the Board of Supervisors action regarding short-term vacation rentals. So that's on the next agenda. So just a point that Kim would like to point out.
Okay, thank you.
Is that a follow-up, or have they dealt with it?
Yeah, the short-term vacation rentals went to the board this past Tuesday.
Right.
And so this is a follow-up and just an update on what occurred.
Okay, item B, items the planning commission wishes to discuss or introduce. No comments, nothing to further? Okay, then we will adjourn the meeting. Thank you, we'll see you all next week.